So good afternoon and a warm welcome to all of you, quite literally warm, seeing the sunshine today, to this webinar, which is focusing on Section 117 of the Mental Health Act 1983, which, as I anticipate you already know, concentrates on the provision of aftercare services for patients who have been detained under the Mental Health Act. Today's webinar is brought to you by representatives of the Court of Protection team, of which Tim is the co-convener, together with James Holmes. And the event title carries with it the words "A Patient's Perspective." And this isn't meant to imply that public bodies don't act without the patient's perspective in mind, in the same way that acting on a patient's behalf doesn't mean that Tim or I aren't alive to the difficulties faced by the public bodies due to funding constraints and the impact of restructuring. We hope that today's webinar will look at, by way of sharing perspectives, in order to assist in whichever part of the dispute that you as an attendee at today's webinar may sit. Hopefully there'll be an opportunity for questions. If so, please use the Q&A box, which should be there at the bottom of your screen. If it isn't and you click the three little dots that say more, then the Q&A box should appear. Sometimes, please note, we will be unable in this forum to answer case-specific inquiries. The event's designed to provide information to help navigate the law and procedure when there's a disagreement as to which public body is responsible for aftercare provision. And we know that such disagreements can delay tribunals and present difficulties for patients in the community. So just before we start in earnest, Sophie, if you wouldn't mind just clicking over to the intro slide, the next one, that would be great. I'm going to speak briefly for about 10 minutes to set the Section 117 scene, so to speak, and then Tim will take up the substance of the dispute resolution regulations, how they impact on the issue of ordinary residence when it starts to become a tense issue in proceedings. So just to introduce Tim Baldwin, as I've said, he's co-convener of the Court of Protection team and also the mental health team. He has considerable experience in these areas, as well as being an established practitioner in public law across areas of community care, social housing, civil liberties and human rights, in respect of all of which he is ranked in the legal directories. Importantly, Tim previously has advised Mind when they were making their submissions on the amendments to Section 117 of the 1983 Act, when it was amended by the Care Act. So Tim, extremely well placed to give you an insight onto the topic in this webinar. So just to start, what is aftercare and who is entitled to it, etc., is what I'm going to cover. So if I could just ask you, Sophie, to tip into the next slide. You'll be familiar, I'm sure, with Section 117, subsection 6, which defines aftercare services in relation to a person. It means services which have both of the following purposes: meeting a need arising from or related to the person's mental disorder, and reducing the risk of a deterioration of the person's mental condition, and accordingly reducing the risk of the person requiring admission to hospital again for treatment for mental disorder. So it follows that it is a joint duty of the what used to be the CCG, Clinical Commissioning Group, now the ICB, following the Health and Social Care Act 2022 in England, or the local health board in Wales. So it's that duty plus the duty of the local social services authority to provide or arrange for free non-means tested aftercare services to be provided. And next slide, please. Thanks, Sophie. So aftercare services are fleshed out in terms of the definition in the Code of Practice for the Mental Health Act 1983. We know that the new Mental Health Act 2025 will have a new Code of Practice, but at the moment this is the one that is operational. Chapter 33 of the Code deals with aftercare. Separately, chapter 34 deals with the care programming approach, but concentrating on chapter 33, I'm going to pause for a moment because somebody has raised a hand and I just want to check that they can hear what is being said, but maybe that hand has was an error. So chapter 33, the ICB and local authority should interpret the definition of aftercare services broadly, and then it sets out how broad this is. So not just healthcare and social care, but accommodation, other needs, social, cultural, and spiritual, if these services meet a need that arises directly from or is related to the particular patient's mental disorder and help to reduce the risk of a deterioration in the patient's mental condition, all of which is designed to prevent an admission or a readmission to hospital for treatment. So aftercare, vital component in the patient's overall treatment and care, as well as meeting their immediate needs. Aftercare should aim to support them in regaining or enhancing their skills in order to cope with life outside hospital. And the code continues on the next slide. I'm an arm's length away from controlling, I'm afraid. Thanks, Sophie. So although the duty to provide aftercare begins when the patient leaves hospital, the planning of it has to start as soon as the patient is admitted to hospital. And I pause there to say, so it might be quite early on that any potential dispute might be flagged. But I continue with the code. The ICBs and local authorities should take reasonable steps in consultation with the CPA care coordinator and other members of the MDT to identify appropriate aftercare services for patients in good time for their eventual discharge from hospital or prison. So, and then the next paragraph deals with the need for tribunals to be given really up-to-date information, particularly if there's a likelihood that a patient could be discharged. Moving on to the next slide, the patients who are entitled to aftercare include patients who have been detained for treatment, therefore not under section 2 for assessment, but under sections 3, 37, 45A, 47 and 48, who have been detained for treatment and then subsequently ceased to be detained. And this includes patients who have been granted leave of absence under section 17 and patients on community treatment orders. It applies to people of all ages, including children and young people. And it continues. And it continues until the public bodies, that's the ICBs and the local authorities, are satisfied that the person no longer requires those services. And that satisfaction in due course, when the reform to section 117 is introduced by the Mental Health Act 2025, section 46, subsection 2, that satisfaction will be expressed in writing when the public bodies jointly give notice to the person concerned that in their view, the public body's view, that person no longer requires the services, and so those services will come to an end. That provision has not yet come into force. Next slide, please. Thank you. I'm going to just spend a moment on this, just in relation to something that happened. The tribunal had a restricted patient before it. It agreed with the clinical team that this patient should be conditionally discharged. The conditions couldn't be met, and there was a deferral, and then there was another deferral. And in the meantime, efforts were made to try and meet the condition. And the only condition that couldn't be met was the appointment of a community psychiatrist to accept the patient. The CCG, as it was then, just before the 2022 Act, before they became ICBs, consistently expressed its willingness and preparedness to commission the service, but the NHS trust concerned and another NHS trust on the border geographically, neither of them could provide a community psychiatrist, and that led to tension between the public bodies. When permission to judicially review the failure to fulfil the Section 117 duty, a social supervisor was appointed, but the absence of the community psychiatrist remained an issue. In that case, the CCG argued it was using its best endeavours to try and compel a community psychiatrist to accept the patient, but there was a dispute between the different trusts, and that couldn't be resolved. And so a psychiatrist within private healthcare was commissioned to fulfill the conditions so that that patient could, in fact, in due course, be discharged. And next slide, please, Sophie. So that was an ordinary residence dispute, but not in this technical sense, between trusts who between them couldn't get together to produce a community psychiatrist. Ordinary residence has been obviously considered in the Worcestershire case, the Supreme Court case, and it's given life, as it were, within the care and support regulations, which Tim will be talking about just in a moment. I just thought it was interesting when I saw on the Department of Health and Social Care website the updated invitation, if I can put it that way, that if in light, as because the cases were stayed, ones that were dealing with ordinary residents were stayed awaiting the outcome of the Supreme Court. So the website says we'll carry on accepting new referrals. That's the Secretary of State will continue to accept new referrals in line with the care and support dispute regulations. But if you feel that a determination is no longer needed, then contact us. I don't know whether that's wishful thinking with the department hoping that people will come to their own agreements and reduce workload. I don't know. But in any event, that is the up-to-date position on the website. And finally, before I hand over to Tim, if I can just flag a couple on the next slide. There are a few resources. It's useful sometimes to have sight of a Section 75 partnership agreement, because that can give you an idea as to some of the background of what has led to public bodies taking a particular position. There's obviously the NHS guidance that was updated in August of last year, and there's some ombudsman resources there which focus on Section 117, how the complaint mechanism works and what remedies are available. So sorry if that's super quick, but I'm conscious that Tim has a lot to get through, so I'm handing over now to Tim. Thanks.
They're asking what case, please, and I think that was in respect of the case that you referred to.
You mean the case of the tribunal and the dispute between the trusts?
Yeah.
Yeah, that case wasn't reported, and it's some years ago now, so I'm afraid there's no citation for it. It's my own experience.
Okay, thanks. In terms of what we're looking at today is to look at ordinary residence disputes and look at the importance of the patient perspective. And you'll see that resolving these disputes in the end is the mechanism is quite distant from the patient. And one of the key things is how disputes as to ordinary residence, as to aftercare provisions, can impact on the decisions of mental health tribunals to discharge a patient. Often in um, decisions to discharge a patient, aftercare is a key consideration by the tribunal, and ordinary residents' disputes within that, the resistance of any local authority to undertake the social care responsibilities for a particular patient can lead to a block and a number of adjournments of those tribunals. And also, when one looks at the new powers under the Mental Health Act 2025 in respect of conditional discharge and supervised conditional discharge, those are also linked into issues of ordinary residence and disputes as to aftercare provision. So it can be quite complicated in terms of tribunal decision making if there is no um, local authority willing to undertake the obligation to provide aftercare provision. Also, these can be a block from release from hospital because not all patients are discharged via the tribunal. So hospital managers may be faced with difficulties if aftercare provision is not accepted by a local authority. Also, you can have issues around transferred patients, those who were prisoners or in immigration detention who've been transferred to um, hospital and then either returned to hospital or out into the community. Though those types of individuals can encounter great difficulties if there is an aftercare dispute. So what I'm going to try and look at is what is the legal framework and how a patient might does not formally, because when one looks then accept uh, responsibility for aftercare and other local authority, but it can use the mechanism and the guidance that's given both in the regulation and the care and support. So we'll also look at what the reforms are for aftercare under the Mental Health Act, and will these help or hinder if and when they're in force? To answer a question that was posed in the chat early on, um, the government have said it may take 8 to 10 years for the Mental Health Act 2025 to come into force. Uh, One of the reasons is for the training of staff to adapt and also to produce the updated code of guidance, code of practice. Don't really know when, if and when, the reforms to aftercare will come into force. All that we have is a broad indication that they're trying to move as quickly as possible, and possibly we'll see some greater implementation in 2027. But we really have no idea as to when and if these provisions will come into force. So Helen touched on this, and this is the duty. Sorry, you've skipped. That's it. Yeah. Although the duty is a joint one, it doesn't mean that the cost of incurred in providing services would be shared, should be shared between the authorities, irrespective of the nature of the service being provided. So the allocation of cost will depend on the specific aftercare service being provided. And that may be that a local authority has a greater obligation in terms of cost than a health body. But the duty is joint in the sense that authorities must collaborate and plan together when providing or arranging to provide services under Section 1176 that come within either their health or social care responsibilities. And the care of support guidance under the Act, paragraph 7 of the Care Act at 7.23 states, Section 117 of the MHA places a duty on the NHS and local authorities to provide aftercare. So there is a clear duty to provide this, and will usually involve a joint assessment, often under the CPA, now the Community Mental Health Framework, including an assessment of the person's care and support needs, a care and support plan and subsequent review, which may reach a decision that a person is no longer in need of aftercare. So that is what the Care and Support Statutory Guidance provides for. And paragraph 45 of Annex A identifies that the legislative requirements for a care and support plan under the Care Act do not apply to this section. So there's no notion of eligible um, uh, uh, care and support needs. The care plan should now instead be drawn up under the guidance under the Community Mental Health Framework for adults and older adults. And that you can find that in the link there. Next slide, please. Ordinary residence dispute. So one can find this in sections 117, 3 and 4 of the Mental Health Act. And what it does is identify who the various bodies are under subsection 3. And it says at 3A, if immediately before being detained, the person concerned was ordinarily resident in England for the area in England which he was ordinary resident. B, if immediately before being detained, the person concerned was ordinary resident in Wales for the area in Wales in which he was ordinary resident, or in any other case or any other area which the person was concerned or which he was sent on discharge by the hospital in which he was detained. So before or where he was sent to. And in particular on the issue of dispute, it's subsection 4. And it says where there is a dispute about where a person was ordinarily resident for the purposes of subsection 3, A, if the dispute is between local social services authorities in England, section 40 of the Care Act applies to the dispute, as it applies to the dispute about where a person was ordinary resident for the purposes of Part 1 of that Act. So the dispute resolution mechanism is within the Care Act. There is no specific dispute resolution within the Mental Health Act, so it's a cross-reference to another piece of legislation. Similarly, if there's a dispute in local services authorities in Wales, it's section 195 of the Social Services and Wellbeing Wales Act 2014, which it is an equivalent of the Care Act. And that applies to the dispute as if it were a dispute of ordinary residence for the purposes of that Act. So, and if the dispute is between local services in England and local social services authority in Wales, it's to be determined by the Secretary of State or the Welsh ministers. I'll touch on that very, very briefly in a moment. But subsection 5, the Secretary of State and Welsh ministers shall make and publish arrangements for determining which of them is to determine the dispute under 4C, and arrangements may in particular provide for a dispute to be determined by whichever of them they agree to do so. So that deals with an approach where you have cross-border disputes under the Mental Health Act 1983 between when someone's either in England or Wales. And that is, for example, if somebody was ordinarily resident in England but detained in hospital in Wales or vice versa. There is no similar equivalent for dispute in Northern Ireland. There is no similar dispute resolution process for someone who's detained in Scotland because they have separate pieces of legislation that deals with the Mental Health Act. So what happens if there is no referral either under section 40 or section 195 when there is a dispute between local authorities as to responsibility for provision of aftercare services? Next slide, please. Ordinary residents. So one has to look both at the common law and the statute here. And in terms of ordinary residents, the relevant authorities prior to the Care Act coming into force was where the person was resident before being detained, or whether the person was sent on being discharged. But as a result of the Care Act from the 1st of April 2015, authorities are those where a person was ordinarily resident in England and Wales before being detained, and in others where the place where the person was sent on discharge. So there's a change in language, a difference between being resident and ordinarily resident. And the place or ordinary residence is a place where they are in fact ordinarily residents as determined by the common law. And that is for the purposes of local authority services under the Care Act. There's no similar deeming provision as there was under the National Assistance Act. The leading authority to be taken on the words ordinary resident is the case of Shah. And Shah, and subsequent case laws, is considered on a note on ordinarily resides in 26(4) under the Care Act. And it's clear that this is a complex issue, and also the significance of Section 39(4) of the Care Act says, in confirming that unlike the rules in adult social care legislation and the Children Act 1989, the ordinary residence rules in the 2014 Act and Section 117 of the 1983 Act are not congruent with each other. So that's a specific provision is needed to align them where they interact. And that comes from the Worcestershire case, where prisoners who have been previously detained in hospital under 47 and 48 and transferred back to hospital, transferred back to prison, you'll see their specific requirements are set out in sections in paras 17.6 and 17.7 of the Care and Support Guidance. But if we go to the next slide, we'll start to get an understanding of how disputes may be resolved. Next slide, please. So ordinary residence disputes, local authorities. So Section 40 of the Care Act provides that where there is a dispute about where an adult is ordinary resident cannot be resolved by local authorities in England. You have the similar provision under the Welsh legislation. The local authorities involved may, so it's a power, may request a determination of ordinary residence to be made by the Secretary of State or a person appointed by the Secretary of State. So that is different to what happened under the previous legislation. Linked to that is Section 41 of the Care Act, and that allows for expenditure to be borne by a local authority in provision of services under this section for a person ordinarily resident in the area of another local authority to be recoverable from that other local authority. An unlawful failure for a lead authority, and we'll come back to that shortly, a lead authority to act or any authority to act and seek interim relief on without prejudice basis pursuant to Section 41. You can join, therefore, the Secretary of State as an interested party to any judicial review proceedings, and you can do it effectively on a without prejudice basis if you have a dispute between local authorities. So you can identify a lead authority if they're not referring, and another authority, and to get provision from one authority first, whereby that authority can then recoup any expenditure that's wasn't justified in terms of them expending from the other authority. So you can move to seek assessments in that way without waiting for the Section 40 procedure to kick in. In any event, the Care and Support Dispute Regulations, local authorities, 2014 289 to 29 set out the procedure to be followed. And that is set out quite clearly in the care and support guidance. If we go to the next slide. So this is in detail setting out what happens if you have a dispute between two or more local authorities as to whether someone was ordinarily resident in their area and their obligation to meet their aftercare provisions. So the starting point on this is paragraph 1977 of the care and support guidance, which reflects what is set out in the regulations. And it sets out the procedures that the local authorities must follow when disputes arise between local authorities concerning a person's ordinary residence. And what it says is that when a dispute between two or more local authorities occurs, local authorities must take all reasonable steps to resolve the disputes between themselves. So there is no obligation on the patient to try and resolve this dispute. The obligation is on the local authorities to resolve the dispute which they are in. Somebody must be responsible for the aftercare provision of a particular patient, and it's down to the local authorities to resolve that. And what guidance and the regulations give is that it says that it is critical that a person does not go without the care they need. So there appears to be an additional obligation in this process, in addition to just resolving the dispute as to who is responsible. There is an additional obligation on one or more of the local authorities to ensure that the person who is subject to the aftercare duty does not go without the care they need. And it says the local authorities that are meeting the needs of the adult or carer on the date the dispute arises must continue to do so until the dispute is resolved. So there must be one of the local authorities that takes up the baton, does an assessment of the person's needs and meets those needs until the dispute is resolved. So there's arguably a distinction between the obligation to resolve the dispute and the obligation to meet the person's aftercare needs. And it says if no local authority is currently meeting the person's need, then the local authority where the person is living or is physically present must accept responsibility until the dispute is resolved. That can be somebody who is still in hospital. So they are physically present in the area where the person is detained. The local authority which has accepted provisional responsibility, and that's what we're talking about here, that is provisional responsibility to meet the needs of the adult or carer, and that includes involvement in assessing their aftercare needs, is referred to as the lead authority. I have dealt with cases where there's a dispute between the authorities who should be the lead authority. If you can identify them who should be the lead authority, then it's easy because they have the duty under the regulations and this guidance to meet the person's needs until the dispute is resolved. And the obligation on the lead authority is identified in 1978. The lead authority must identify the authorities involved in the dispute and coordinate an ongoing dialogue between the parties involved. So this is a dispute resolution mechanism that is supposed to work. the parties involved must provide the lead authority with contact details of named person in relation to the dispute. The lead authority must be responsible for the coordination of any information that may be relevant to the dispute and keep all the parties informed of any developments that may be relevant to the dispute. The lead authority must also keep the person, that is the patient, or their care if appropriate, fully informed of the dispute in question and of the progress regarding any resolution. This is the obligations under the regulations as identified within the guidance. This is where it often goes wrong because local authorities will not accept whether they are the lead authority or will point a finger at another local authority. Admittedly, quite rarely, but it can happen when it's very difficult to identify where somebody was living before they were detained, or they have moved around an awful lot. That can be a major problem. And it then says in 1979, if having followed the procedure set out in the disputes regulations, the authorities are still unable to resolve a particular dispute, then the lead authority must apply for determination to the Secretary of State or appointed person. So that would be under the different provisions either within England or in Wales. This should be done as soon as the local authorities agree they are unable to resolve it. So it should be a quick process. It shouldn't drag out. If they can't resolve it, they have an obligation to refer it. And a failure to refer it, although the patient cannot directly force under the dispute resolution mechanism for the Secretary of State to say, should be this, it should be that local authority. It's clear that the patient can, by way of judicial review, challenge the mandatory obligation to refer when a lead authority refuses to do so, or a local authority will not identify themselves as a lead authority in order to do so. And in any event, there is a time limit on this by no later than 4 months of the date dispute arose. So, that is the cutoff point. If there is no resolution by that point, then a patient is enabled to quite swiftly seek resolution on the failure to refer or the failure to identify a lead authority to refer as of 4 months of the date when the dispute arose. And the provisional acceptance of the responsibility of a lead authority does not influence the determination made by the Secretary of State. So it's a without prejudice referral to enable the Secretary of State to resolve the dispute. Next slide, please. Other bits of the guidance which are useful to look at is paragraph 1963. That is the duty on local authorities to provide or to commission or provide mental health aftercare rests with the local authority in which the person concerned was ordinarily resident before they were detained under the 1983 Act, even if the person becomes ordinarily resident in another area after leaving hospital. And you can see in the guidance here that at 1964, it gives a guidance as to how to approach this under Section 117 as amended by the Care Act in terms of movement and ordinarily resident. And it says at 1965, if, however, a patient is not ordinarily resident in England or Wales immediately before being detained, the local authority for commissioning the patient's aftercare will be the one in the area in which the patient is resident. So you go from the concept of ordinary resident to the concept of where the patient is resident, so actually where they physically are. And it says only if that cannot be established, either will the responsible local authority be one for an area to which the patient is sent on discharge. However, local authorities should only determine uh, uh, that a person is not resident anywhere as a last resort. Next slide, please. And what this part of the guidance deals with is a specific issue in respect of Section 39(4) of the Care Act, which is a deeming provision that applies to any person who is provided with accommodation as part of their aftercare. Not everybody will be provided with accommodation as part of their aftercare. And the effect of 39(4) is that the person is deemed for the purposes, Part 1 of the Care Act, to be ordinary resident in the area responsible for the person's aftercare. What I've highlighted here, that this will apply to any person who applies, any person who receives aftercare on leaving hospital on or after the 1st of April 2015, irrespective of the date they were discharged from detention under any relevant provisions under Section 117(1). And you can see that there are exceptions from this where the deeming provisions do not apply under Section 117, nor have they been incorporated into 117 of the 1983 Act. And it reiterates at 1968 as to the mechanism for resolving a dispute between local authorities in respect of aftercare. Paragraphs 1980 to 1987 highlights the process for determination by the Secretary of State or the Welsh ministers, and 1988 and 1999 talks about financial adjustments between local authorities. For example, if one local authority undertook to provide the person with aftercare, but then it was determined that they were not the relevant local authority for the purpose of ordinary residence by Secretary of State, then they can recoup their expenditure from the local authority who has now been determined to be responsible. And 1990 to 1991 deals with reconsideration of disputes. Next slide, please. Ordinary residence disputes, residence in hospital. It's a peculiar one because although it's not possible for a patient to be resident in hospital during a period of detention, if one looks closely at the case of Hertfordshire and Hammersmith or Fulham, it applies to ordinary residence of a patient. And it is possible for a detained patient who subsequently attained informal status to attaining ordinary resident status if they become an informal patient. So it's a subtle distinction between being someone who is resident in an area and someone who is ordinarily resident in an area if they become an informal patient after being detained. It's important really to look at when one is looking at bringing a judicial review claim, because you'll often want to join the Secretary of State in as an interested party. And these are the relevant referral addresses which are in the guidance and to be used to serve either the pre-action letter or the claim on them. And there is a specific process, as I said, for resolving disputes between England and Wales as to when you've got a cross-border issue, but there is nothing for Northern Ireland. Next slide, please. This just reaffirms what Helen said in terms of the nature and extent of aftercare. One of the key things to always identify is the fact that there's a case called AIF work, where ordinary accommodation is not considered as accommodation provided for under Aftercare under Section 117. And also, it's clear that aftercare planning in young persons is distinct from that for adults. And what I've set out here is the uh, the clear requirements in terms of what aftercare services are aimed at, and that is reducing the risk of the person requiring admission to hospital again for treatment for a mental disorder. And within that, I say that the present reforms about conditional discharge and supervision is relevant to these aftercare considerations. And you can see that the nature and extent of aftercare, uh, uh, the bodies who provide aftercare must have regard to their other demands and budget. So resources can still become an issue. Next slide, please. So really problems and how can a patient challenge failures. And the key consideration is really that the patient doesn't have a direct route of challenging the ordinary resident's determination. But it's first of all, it's critical from 1977 of the guidance, a patient doesn't go without need. So there is still an obligation on some local authority to be involved in the assessment process and meet that. And it's clear that if no local authority appears responsible, it says if no local authority is currently meeting the person's need, then the local authority where the person is living or physically present must accept responsibility until a dispute is resolved. So that if there's a dispute between two local authorities in one part of London, but somebody's in hospital in another part of London, then the local authority where the hospital is based must become the lead authority. And that when the local authority which has accepted this provisional responsibility, then they are referred to as the lead authority. So they are responsible for dealing with the dispute, and it must be resolved within 4 months. And then there must be a referral to the Secretary of State. And it's pretty clear that the obligation to conduct an assessment and meet the need is a distinct obligation from the resolution of the ordinary residence dispute. So it's clear that the needs and rights of the patient are paramount in terms of this, and that the dispute about ordinary residence can go on in the background. And here's a couple of examples. A case of RB versus Lambeth and Fulham and Secretary of State IP. So a case that I was involved in, and it involved an accommodation issue in the community where a person was involved in a criminal offence. They were detained under Section 3, then discharged and accommodated and provided with care in the community. And that was due to end. And there was a dispute between Lambeth and Croydon as to where this person was ordinarily resident. The offence had occurred in Lambeth, and this person from abroad who was facing criminal charge. And what this led to was a judicial review claim with interim relief where the provision of accommodation was sought on a without prejudice basis and aimed at Croydon, who was considered the lead authority. And what that led to was a court order requiring Croydon to accommodate and provide aftercare until the matter was resolved. And what happened in that case was Croydon then accepted the lead role and accepted the dispute resolution process that they would make the reference if it wasn't resolved. Rod Taylor Campbell provided us with a very interesting one where it's a dispute between two local authorities, and a second local authority was identified as an interested party, not a defendant. And this identified clearly a separation, a delay in assessing someone's needs from referral and permission for judicial review and interim mandatory orders in order to assess were made. Other examples that I've dealt with is concerning tribunal decisions delayed where someone is falling between three authorities. In the end, we end up going to the authority where the person is in hospital. Next slide, please. So very briefly, what does the Mental Health Act 2025 do? Section 46 merely amends subsection 3. So it introduces a new 3A. And it places a duty on local social NHS and local social services authority being detained in hospital, and it refers to subsection 2, and subsection 3 applies the following deeming rules under social care legislation, and the amendments here concern both the consideration of children and adults. Next slide, please. In respect of adults, the deeming rules under section 29, 1 to 3 of the Care Act apply. And this provides where a person has needs that can only be met through care home, supported living, or shared lives accommodation, and are living in that accommodation, they are treated as ordinary resident in that area they have lived in immediately before they moved into this accommodation. Similarly, in respect of Wales, a deeming rule under 193, 1 to 3 of the Social Services and Wellbeing Act apply. And also there's reference to cross-border provisions. Next slide, please. So the broad effect of reforms to subsection 3 is where a local authority arranges for or provides a child or adult with accommodation in another local authority area B as part of their aftercare provisions, the person will remain ordinarily resident in the area of local authority A. This means that a person is re-detained under subsection 3 or qualified section when they cease to be detained and they leave hospital. They are ordinarily resident in local authority area A for the purposes of section 117. And where an adult or has been detained under section 3, other qualifying section, immediately before they are detained, they will be living in a specified accommodation, the Care Act or Social Services Act, Wales Wellbeing Act. Then respective deeming provisions should be used to determine the person's ordinary residence. This will mean that when they cease to be detained or leave hospital, they'll be ordinarily resident in the area they were living immediately before moving into the specified accommodation. So these provisions are aimed at someone needing specialist accommodation as part of their aftercare. And there are practice example notes in paragraphs 342, 343, and 344 of the code of the explanatory notes to the legislation. Next slide, please. But what happens if there's no accommodation need? What happens there? The main cohort of adults detained under Section 3. And this is a practice example under para 343. The following sets out the practice example of how reforms to subsection 3 work, where aftercare does not include accommodation. So there's a distinct distinction between persons who need accommodation and persons who don't. If an adult lives in local authority A, this adult is detained under section 3 of the Mental Health Act. Local authority A is responsible for the adult's section 117 aftercare, which involves community youth support. The same adult moves of their own choice to local authority B, so it's about own choice here, whilst receiving section 117 aftercare from local authority A, the patient is detained again under section 3 of the Mental Health Act, or on discharge moves back to local authority B. At this point, local authority B becomes responsible for the person's aftercare. So there's a distinction you can see between people who are in need of accommodation as part of their package and people who are not in need of accommodations. And that is specialist accommodation. Next slide. So, will problems still exist on disputes of ordinary residence? Uh, Section 40 and 41 are not being uh, repealed, as far as I can see. So there will well still likely be um, disputes on ordinary residence when and if these reforms come into force. So thank you. If you have any questions, um,
Thanks
now's the
so
time to
much,
ask.
Tim. That was great. Apologies for any loss of connectivity. I hope that it improved when we removed our faces. Thanks very much, Tim. That was really great. Just bringing into focus the juxtaposition of the Care Act and the Mental Health Act and the regulations and how they apply. There is a question which I've tried to answer as many as I can, but there's one that says, what about disputes between ICBs regarding the provision or funding of health-related interventions, e.g. psychological therapy? I understand this is supposed to be governed by the Who Pays guidance, that's the NHS guidance that we've referred to. But the rules seem to differ. So you can have the responsible local authority in one geographical area, the responsible ICB in another, and that can cause problems. For example, an ex-London resident who's being detained or placed in Devon. So the health-related intervention of psychological therapy is presents a conundrum in my experience. I don't know whether, Tim, you have an easy answer, but the type of aftercare services sometimes is a discrete dispute on its own, with some people saying that it's more health or less health related.
I mean, it is difficult because the question is it, often psychological therapy provision can be provided via local authority provision through sort of forms of community mental health teams and so on and so
Mm,
forth, or referral to a private provider. So the question always is, well, if that is part of the aftercare, if there is a requirement for that as part of
mhm,
the aftercare provision, who should be funding it?
mhm,
It would seem on the face of it that it would be primarily a healthcare obligation
mhm.
because who would normally commission that, and what is the route of commissioning that psychological therapy? Because psychology is really a healthcare need because you get psychological intervention within hospital. You get
Yes,
psychiatrists, you get psychologists,
psychological therapy.
and there is often, but there should also be a clear distinction between what is a pure community mental health
Hmm.
um, psychological therapy intervention. Well, for example, if someone is not detained under Section 3, was merely detained under Section 2, so it would be responsibility for primary mental health services, not secondary.
And
So
they wouldn't be entitled to aftercare from
no,
section
so it's
117.
really looking at whether I think whether that is a secondary um, uh, second tier mental health intervention that is part of the aftercare care plan. And I would have thought that if it is clearly health related and not social care related in terms of it's not a social worker who provides you with
Mhm.
that. It's not uh,
Mhm.
that it should be funded by the
Yeah,
ICB.
CB. I appreciate that we've just gone over 2 o'clock, but
Yeah,
just in relation to one thing that you said, Tim, it
yeah.
may help others clarify the description of a specialist accommodation
Hmm.
under section 117.
I think that would be things like supported living placement,
Yeah,
a hostel, a care, a residential care home,
yeah.
it wouldn't, for example, what I talk about non-specialist is that if all your needs was to have a either a privately rented or a rented flat from a local authority or a um, social housing provider. So where effectively as part of the package of living at that residential placement, you are getting extra services beyond that
Yeah,
of people coming and providing you with domiciliary services.
which is associated with the type of accommodation that
Yeah.
you're living in. Um, I'm afraid we're coming up to 2:05. I'm sorry we haven't been able to get to through every question, and I hope that there will be. If you have specific queries, then please do get in touch with us. We'll see if we can help. But for now, thank you very much for your attendance and have a good afternoon. And thank you to Tim for the lion's share of going through the legislative provisions. Thanks very much.